$7.4 trillion is sitting in 401k accounts right now across the United States. And for the last several decades, a quiet, legal, systematic percentage of every single dollar in those accounts has been drained by fees most people never thought to question. Not because you weren't paying attention, because the system was designed so you wouldn't need to. The Supreme Court just changed that. 9 justices, 0 dissents. And here's the part nobody is reporting correctly. This ruling doesn't just protect future retirement savers. It opens a retroactive legal window on money that has already left your account. Money you didn't know you were paying, to parties you never agreed to pay, under arrangements your employer never explained to you, if you have a retirement account of any kind. This is the most important legal development of your financial life that isn't on the front page. Here's what they actually decided, and this is sharper than the headline suggests. The court didn't just rule in favor of a few university employees suing Cornell. They dismantled the legal wall that plan administrators have been hiding behind for years. They said, you do not have to disprove a statutory exemption before you even get to see the evidence that would tell you whether an exemption applies. In legal terms, that is the difference between a lawsuit that gets thrown out in 6 months and one that survives to discovery where the real numbers live, where the revenue sharing agreements sit, where the actual math of who benefited from your retirement plan gets examined by someone other than the people who wrote the contract. The door to that room just swung open, and some very large financial institutions are currently having very uncomfortable Monday morning meetings. Look, I want to tell you exactly what happened, why it matters, and what you should do about it in that order. No vague warnings about the system, no dramatic pauses where I widen my eyes at the camera. I'm going to show you the specific mechanism by which money has been leaving your retirement account without your knowledge. How a 9-0 Supreme Court ruling changes the legal math on that, and what the practical moves are for someone who is 30, 40, or 50 years old and is trying to retire with dignity rather than desperation. Here's why this has been misreported everywhere else. Most financial content is either too technical to be useful or too simple to be accurate. This case, Cunningham v. Cornell University, decided in April of 2025, sits at the intersection of employment law, fiduciary duty, and compounding fee structures. Most journalists don't want to read the actual opinion. It's dense, it's procedural. It requires understanding ERISA, which is the Employment Retirement Income Security Act, which governs essentially every employer-sponsored retirement plan in every state in the country. I read it, so let me translate it into something you can actually use. Imagine you hire a property manager to run your rental property. You sign a contract. The contract says they take 10% of the rent collected. Fine, standard deal. You understand what you're signing. But then, quietly, the property manager also starts billing your tenants for an administrative coordination fee, a maintenance readiness assessment charge, and an occupancy optimization surcharge. The tenants pay it. You never see the itemized breakdown. Your monthly checks look roughly normal. Your annual statements say everything is fine. But the property manager is skimming. And they can keep skimming as long as you never ask the right questions, and as long as the court system says you have to prove the skimming didn't fall under some exemption in the original contract before you can even file a complaint against them. That is exactly what has been happening inside 401k plans in this country for the last 30 years. Your employer hires a plan administrator to manage your retirement account. That administrator has enormous discretion over which investment funds to offer participants, which record keepers to use, what fees to charge, and what revenue sharing arrangements to negotiate with fund companies. And for decades, the legal pleading standard in ERISA cases made it nearly impossible for employees to get a lawsuit past a motion to dismiss, because courts were requiring workers to negate statutory exemptions up front before they had access to any discovery that would show them whether those exemptions actually applied. The property manager. That's our metaphor for the day. It returns every time the legal language gets complicated, because what this case really comes down to is one question. When the property manager is skimming, who has to open the books first? In a few minutes, I'm going to show you exactly how much money has moved out of average American retirement accounts through this mechanism over a typical career. The number is going to feel abstract until you attach it to something real, and then it won't feel abstract at all. But first, let me explain the ruling itself, because the legal mechanism is what makes everything else possible. The case is Cunningham v. Cornell University. A group of employees sued Cornell over its retirement plans, alleging that the university as plan sponsor had selected investment options with excessively high fees, some of which were proprietary funds offered by the plan's administrator, and that revenue-sharing arrangements between the fund companies and the plan created conflicts of interest that violated ERISA's fiduciary duty requirements. ERISA Section 1106 prohibits certain transactions between a plan and what's called a party in interest, essentially anyone with a financial relationship to the plan. But Section 1108 carves out exemptions to those prohibitions for certain kinds of service arrangements. What the lower courts had been doing, and what made these cases almost impossible to win, was requiring plaintiffs to plead facts, negating the Section 1108 exemption in their initial complaint, before any discovery, before they had access to the service contracts, before they could see the revenue-sharing arrangements, before they knew anything the plan administrator wasn't voluntarily disclosing. The Supreme Court said unanimously, no, file the complaint, allege the prohibited transaction. If the administrator wants to claim an exemption as a defense, they raise it as an affirmative defense and carry the burden of proving it. You do not have to disprove it before you even get to ask for the documents. Think about how structurally broken the old standard was. You have to prove the property manager wasn't just following the contract before you can see the contract. You have to disprove an exemption without access to the facts that would tell you whether it applied. The court looked at that arrangement and said, essentially, that's not how burden allocation works in American courts, and there's no reason ERISA cases should operate by a different set of rules. This is not a small procedural tweak. Before this ruling, law firms representing employees would frequently decline ERISA fee cases because the motion to dismiss risk was too high. You'd invest months building a case, and then a judge would throw it out because the plaintiff couldn't negate a statutory exemption without the discovery that proving the exemption would require. Circular, Kafkaesque, and extremely convenient for plan administrators. After this ruling, those same law firms are reopening their intake pipelines. The litigation economics changed overnight. By the way, hit subscribe if you like the content, otherwise YouTube's algorithm may never show you my videos again. I'm going to be covering every major state-level response to this ruling over the next several months, and there are going to be developments that matter directly to your retirement math. You'll want to be here. Now here's where it gets really interesting, because the ruling is the legal mechanism, but the real story is what it's unlocking and how much money we're actually talking about. The average 401k plan in the United States charges total annual fees, that's expense ratios plus administrative fees plus record-keeping costs of approximately 1.09% per year. According to the Investment Company Institute's 2024 data, that's the blended average across all plans. Now, I know 1% sounds like nothing. It's 1 cent on every dollar. How bad can it be? Run the math with me. You're 35 years old. You have $50,000 in your 401k today. You're going to grow this account for 30 years. The market average is 7% annually, because that's roughly the historical real return of a diversified equity portfolio. But your plan is also charging you 1.09% in fees annually. That reduces your effective net return to approximately 5.91%. And over 30 years, the difference between 5.91% and 6.95%, which is what you'd earn with a plan charging 0.05%, the kind of fee Vanguard index funds actually charge, is not a rounding error. On a $50,000 starting balance, with contributions of $5,000 per year, the difference in terminal value at age 65 between a 1% fee plan and a 0.05% fee plan is approximately $158,000. $158,000. That's not lost in a market crash. It's not gambled away. It's extracted quietly in fractions of a percent, 365 days a year, without your knowledge or meaningful consent. And here's the thing about that money. It didn't evaporate. It went somewhere. Specifically, it went to fund managers, record keepers, plan administrators, and through revenue sharing, sometimes back to your employer as an offset against their administrative costs. Your retirement savings, quietly subsidizing your company's operational budget. The property manager, skimming. Here's where I want to make the reversal explicit, because this is the part that most people get wrong. You think the fee is the problem, but actually, the non-disclosure is the problem. Under ERISA, plan administrators owe a fiduciary duty of loyalty and prudence to plan participants. That duty means they're supposed to select investment options based on what's best for you, not based on what generates the most revenue for the plan's vendors or for the employer. A high fee, in isolation, isn't automatically illegal, but a high fee fund selected because it kicks back revenue to the administrator, while comparable low fee alternatives are available, that's a fiduciary breach. That's a prohibited transaction, and proving it requires getting into the service agreements and revenue sharing contracts that until now you had almost no legal pathway to see. The Cunningham ruling opens that pathway. The property manager has to open the books. And what's in those books is going to be very uncomfortable for a lot of people who've been very comfortable for a very long time. Let me tell you about a woman named Margaret. She's been a public school teacher in Ohio for 31 years. Her 401k supplement, the defined contribution piece on top of her state pension, has been managed by the same vendor since 2003. She never changed anything in that account. She picked 3 funds when she was hired at age 31 and never touched them again. That's not lazy, that's normal. The entire industry depends on it being normal. What Margaret didn't know, 2 of her 3 funds were proprietary funds managed by the same company that administered her plan, both carrying expense ratios above 1.1%. She also didn't know that a comparable large cap index fund was available on the same platform for 0.04%. And she absolutely didn't know that her vendor had a revenue sharing agreement with her school district that returned a portion of those expense ratios back to the district as an administrative credit. Under the old legal standard, Margaret would have needed to allege in her initial complaint facts sufficient to negate the Section 1108 exemption. Without discovery, without the service contract, without the revenue sharing agreement, her lawyer would look at the uphill math and pass on the case. Case never filed. Vendor continues. Margaret retires with $130,000 fewer dollars than she would have had in a low-fee plan. And she never knows why her balance didn't grow the way the prospectus suggested it should. Under the new standard, she files a complaint, alleges the prohibited transaction, and the vendor has to raise the exemption as an affirmative defense. The case goes to discovery. The revenue sharing agreement sees daylight. A jury decides whether a fiduciary who offered expensive proprietary funds while pocketing an indirect kickback was acting in her interest. The property manager's books are open. That's the entire game right there. Stay with me, because this next part changes the scope of what we're actually talking about. I want to introduce a second storyline here, because it connects to something even more underreported than the ruling itself. There's a man named Robert. He's 52 years old. He worked for a mid-sized manufacturing company in Michigan for 28 years. He maxed his 401k contributions for most of those years. He has approximately $410,000 in his account. He thinks he's on track to retire at 65. He told me, in almost those exact words, that he's never actually understood what he's paying for his account. He's assumed it was fine. Because that's what you do, you assume it's fine. I asked him to pull up his most recent plan statement and look for his annual fee disclosure. He found it, buried in a PDF attached to an email his HR department sends every July. An email he has never opened because it looks like a legal notice, and he's busy and everything seems fine. His total annual fee, 1.34%. On $410,000. That is $5,494 per year, every year. Coming out of his retirement account for funds he never consciously selected, managed by a vendor he's never spoken to, through arrangements that have never been explained to him. Robert is not a victim of anything dramatic. He's a victim of a system designed to be trusted without being examined. We'll come back to Robert. But here is what nobody is telling you about the state-level implications of this ruling, and this is where the reach of Cunningham extends well beyond the ERISA universe. ERISA preempts most state law when it comes to employer-sponsored retirement plans. That's been true since 1974. But state and local government employees, teachers, firefighters, police officers, municipal workers are in state-controlled pension systems that are explicitly exempt from ERISA, and those systems have been under enormous financial pressure for years. The numbers on unfunded public pension liabilities in this country are somewhere between $3 trillion and $6 trillion, depending on the discount rate you use, and that is not a gap that states have been quietly patching through investment returns. States have been modifying benefits. Illinois cut cost of living adjustments for existing retirees. New Jersey changed retirement age requirements. Kentucky overhauled its entire teacher pension system in 2018, pushing new hires into a hybrid arrangement that looked substantially less generous than the defined benefit plan they thought they were signing up for. In West Virginia, public employees who contributed for a decade under one set of rules found the formula changed partway through their careers. Now, Cunningham doesn't directly govern public pensions. I want to be precise about that. It's an ERISA ruling, and ERISA doesn't cover state pension plans. But here's what it signals from 9 justices who agree on almost nothing. When individuals make long-term, irreversible financial decisions based on existing law decisions to contribute, decisions about retirement age, decisions about how much to save privately, courts should be skeptical of legal frameworks that make those individuals bear the entire burden of proving harm before they can access the facts needed to prove harm. That principle is bouncing around the lower courts right now in ways that public pension attorneys are watching very carefully. 3 separate class action suits against state pension systems have already cited Cunningham in their briefs by analogy. Whether those analogies hold up in courts that are strict about ERISA's jurisdictional boundaries, we'll see. But the direction of travel is clear enough that some state pension administrators are already quietly reviewing their litigation exposure. There's also a tax dimension to this that the mainstream press has mostly ignored. 13 states currently impose state income tax on Social Security benefits. People retire into those states or stay in those states based on the full picture of their tax exposure. If a state changes its tax treatment of retirement income after you've spent years contributing to a retirement account under a different set of expectations, the legal argument that you relied on those expectations and that the state bears some obligation to account for that reliance is now a slightly stronger argument than it was before April of 2025. Not airtight, not automatic, but stronger. Picture a conference room somewhere in a state capital, 12 people around the table. Someone slides a printout across to the general counsel. It says, Cunningham Litigation Risk Assessment. The first line reads, exposure, moderate to significant. The second line reads, recommended action. Do nothing and hope plaintiffs' attorneys focus on the private sector first. They agree unanimously for once. Here's the kicker that turns this from a legal story into a deeply personal one. The institutions most exposed to this litigation wave are not the Fidelities and Vanguards of the world. Those firms run the large, low-cost, heavily scrutinized plans that institutional investors, large unions, and university endowments also participate in plans where fee disclosure has been competitive and transparent for years precisely because the scrutiny was already there. The plans with the most legal exposure are the mid-size and smaller plans, the ones run by regional insurance companies, the ones administered by banks whose primary business is not retirement plan management, the ones where the employer is a 60-person manufacturing company or a regional hospital system, and nobody in HR has the bandwidth to audit the fund lineup. According to the Department of Labor, approximately 750,000 employer-sponsored retirement plans fall under ERISA in the United States. The majority of those plans, by number, not by asset size, cover fewer than 100 participants. Small plans, plans where the employer doesn't have a dedicated benefits team, plans where the fund lineup hasn't been reviewed in 7 years because the broker who set it up gets a quarterly call from someone at the plan vendor, and that's the extent of the governance. Those are the plans where the property manager has had the most latitude to add unauthorized charges. And those are the plans where employees, who are often lower wage workers without access to independent financial advisors, have had the least power to push back. Let me give you a specific case study. So this lands at the level of your actual account. You're 43 years old. You work for a company with 60 employees. You've been contributing 6% of your salary to your 401k for 12 years. Your salary is $92,000 annually. You contribute $5,520 per year. Your employer matches 3%, $2,760. Roughly $8,280 enters your account each year. Your current balance is $114,000. You've been a responsible saver by any reasonable definition. Your plan charges a total annual fee of 1.4%. You've never seen that number. It's in a disclosure document that arrived by email 3 years ago, looked like a legal notice, and was deleted without being opened. Here is what that fee is costing you. On $114,000, 1.4% is $1,596 per year in fees. Over the 22 remaining years until you retire at 65, assuming 7% gross market returns and your continued contribution rate. The difference between your plan's 1.4% fee structure and a comparable low-cost plan at 0.05% is approximately $146,000 in loss compounding. $146,000. That's not a dramatic market event. It's a slow drain. It happens every day in amounts you can't feel, and it accumulates to a number that would materially change what retirement looks like for you. And the question this ruling makes newly relevant is, who captured that money? Was it captured through legitimate service arrangements? Appropriately disclosed, where the fees reflected genuine value delivered to plan participants? Or was it captured through revenue sharing arrangements that benefited the vendor and the employer, while participants paid fees that weren't justified by the services they received? You didn't know to ask. Now there's a legal framework for someone to ask on your behalf. The financial advisor who told me the most useful thing I've heard about this industry spent 15 years inside a major bank before going independent. He said, the retirement industry is built on one core assumption that the average person will never do the math. Not because they're lazy and not because they're unsophisticated, because doing the math requires information they've never been given, time they've never been encouraged to spend, and a level of financial fluency that nobody ever taught them. The entire revenue model of third-party plan administration depends on that information asymmetry staying intact. Cunningham is the first time in a generation that the legal system has meaningfully threatened that model. The property manager has to open the books. And that simple change, who opens the books and when, changes the economics of an entire industry. Back to Robert. Robert spent an afternoon in late spring pulling together his plan documents. He found his annual fee disclosure. After 20 minutes of searching through his plan portal, he found his fund lineup. He identified that his two largest holdings, representing about 60% of his total balance, were in actively managed funds with expense ratios above 1%, offered through a record-keeping arrangement that included disclosed revenue sharing between the fund companies and his plan's administrator. He didn't know whether that was a legal problem, neither would most people. The documents are dense. The relationships are opaque by design. What he did? He called his HR department and asked for the full service agreements between his employer and the plan vendor. He was told those were proprietary. He typed out a written request under ERISA Section 104, which gives plan participants the right to request certain documents within 30 days. He submitted it by certified mail. 3 weeks later, the documents arrived. He spent $350 on a 2-hour consultation with a benefits attorney, a real one, someone who specializes in ERISA litigation, not a general practice lawyer who looked it up on the drive over. The attorney is reviewing the agreements now. The case may go nowhere. The revenue sharing arrangement may fall within a valid Section 1108 exemption, or it may not. But here's what changed because of Cunningham. If that attorney decides the case has merit and files a complaint, it will not be dismissed at the pleading stage simply because Robert couldn't negate the exemption from the outside. The case goes to discovery. The documents are examined. The math is done in daylight. Robert spent 28 years building something. He is now, for the first time, finding out exactly what he's built and whether anyone has been quietly taking a cut of it. That's not litigation. That's financial literacy. Finally, having legal teeth. Here is the practical framework. 3 levels of action. in order of urgency, calibrated specifically to this ruling and what it creates. Level 1 is knowing what you're paying. This week, not next month, this week, log into your 401k plan portal and find your annual fee disclosure. It's called an ERISA 408B2 notice, and it's required to be sent to you at least once a year. If you can't find it in your portal, check your email for something from your plan administrator or HR department that looks like a legal notice and that you've been deleting. The number you're looking for is total plan costs expressed as a percentage of assets. If it's above 0.5%, you should understand why. If it's above 1%, you should be asking specific documented questions. If it's above 1.5%, you should be talking to someone. Level 2 is knowing what you're in. Look at your actual fund lineup. Are any of your funds proprietary, meaning they're managed by the same company that administers your plan or record keeps your account? Compare the expense ratios of those funds to comparable index funds. The Department of Labor has a free comparison tool. Morningstar has a free fund screener. If your plan's large cap fund charges 0.8% and an equivalent Vanguard fund charges 0.04%, someone is capturing that 76 basis point spread. The question this ruling makes legally relevant is, who and was the decision to offer that fund in your plan made, in your interest, or in someone else's? Level 3 is knowing your rights. If you believe your plan's fee structure is unjustifiably high, or that your employer selected investment options in a way that benefited the vendor rather than you, you now have a materially stronger legal framework to pursue that claim. Not because the law changed, ERISA's fiduciary duty has always prohibited self-dealing, but because the pleading standard changed, because the door to discovery is now open. The first step is not a lawsuit. The first step is a written document request under ERISA Section 104. Your employer must respond within 30 days. What's in those documents will tell you, and any attorney you consult, whether there's a conversation worth having. $7.4 trillion. That's where we started. Here's what I want you to understand now that we've worked through all of it. That number is not a neutral figure. It's a measure of American trust, the trust that when people followed the rules, contributed faithfully, left the money alone, and paid whatever the statement said they owed, the system would honor that trust and deliver something resembling what was promised. The Supreme Court's unanimous ruling in Cunningham versus Cornell didn't give anyone a check. It didn't automatically recover $1 that was lost to a fee. It didn't rule that every high-fee plan is illegal or that every revenue-sharing arrangement constitutes a fiduciary breach. What it did was restore a basic legal symmetry. It said, you shouldn't have to prove the property manager wasn't following the contract before you can look at the contract. You shouldn't have to negate an exemption before you can see the facts that would tell you whether the exemption applies. You get to open the books. That's it. That's the whole ruling. And from that simple procedural correction, the entire economic logic of how retirement plans have been administered in this country for 30 years starts to shift. Not overnight, through litigation, through deterrence, through the sheer cost of discovery, making fee extraction strategies less attractive to plan administrators who suddenly have to defend them in front of a jury. 3 things to do. First, get your fee number this week. Not eventually, this week. If it's above 1%, you owe it to yourself to understand what you're paying for and whether a lower cost alternative is available through your employer or through a rollover to an IRA. Second, compare your fund lineup to low-cost alternatives and document what you find. Date it. Keep it somewhere other than your work email. If your plan's fee structure is ever challenged by you or by someone else in your plan, documented evidence of what you knew and when establishes the reliance interest that makes any potential claim stronger. Third, if you are a public employee in a state that has modified your pension benefit formula, retirement age, or cost of living adjustment after you were already a contributing member, meaning the deal changed after you started talk to a public employment attorney. The legal landscape for public pension litigation is moving, slowly but perceptibly, in the direction this ruling points. You should know whether you have standing before the statute of limitations makes the question irrelevant. Lazy investing built more fortune than crypto means. The reason that's true is that for most people, the enemy of retirement security isn't a bad investment strategy. It's a decent strategy, quietly being taxed into mediocrity by fees nobody explained, through arrangements nobody disclosed, in documents nobody was encouraged to read. The Supreme Court just made it legal to examine those arrangements seriously. Whether you actually do is, as always, entirely up to you.